Welcome everyone to this forum on social and economic rights, constitutional design and adjudication. Caribbean people are remarkably creative and innovative. I remember as a young barefooted boy picking green guavas and rummaging for discarded nails to make tops. We had to carefully hammer a nail sharpened by rubbing on concrete curbs through the longitudinal center of the guava to avoid it splitting. That done with a long enough piece of twine tethered and twirled, a flick of the wrist, and the wrist created magic and hours of entertainment. It served us well, these guava tops, maybe even forever in the fertile imaginations that their creation fostered. The Caribbean Court of Justice is in some ways like a guava top. Fashioned from mostly local elements and intended for regional use, it is a unique creation. It has, for the last 20 years, provided an unparalleled and incomparable service to the entire Caribbean region, functioning efficiently, effectively, and justly in its original and appellate jurisdictions, and facilitating through its outreach programs the strengthening of the administration of justice. Sadly, not everyone appreciates the value of local guava tops. Things Caribbean are done in distinctive ways that can be uniquely life-giving and suited for Caribbean peoples. The CCJ, as a unique Caribbean creation, was inaugurated on the 16th of April 2005. Today, on the 20th of February 2025, which happens to also be World Day of Social Justice, The Caribbean Association of Judicial Officers, the CAJO, joins with the Faculty of Law, the UWI Mona, in celebrating the CCJ's 20th anniversary. On this occasion, we want to do two things. The first, trace a salient strength within the CCJ's jurisprudence. And the second, identify an area for future growth and development that is fast emerging as pressing in Caribbean spaces. The area concerns social and economic rights, and the issues involve those of constitutional design and adjudication. In the case of adjudication, which is quintessentially a matter of judging, I believe that the CCJ will sooner than later be faced frontally with whether it will continue with its innovative human rights development or retreat into conservatism and unoriginality in this area. The CCJ's human rights jurisprudence is a hallmark of its legal development. It has grown Caribbean human rights jurisprudence as part of its initiative. For a young court, its moves have been confident and bold, not unlike the ways in which one must unleash a Gorbatop to split an opponent. 20 years on and forged in the Zits and Laban of Caribbean history and colonial experience, the core values of freedom and liberty, equality and justice have compelled robust and watertight innovative argumentation. Approaches that have recognized the value and meaning of sovereignty and supremacy in Caribbean democratic constitutionalism. The approach, now familiar, is, if I may say so, immaculate in its clarity, coherence, and compellability. Indeed, one may say irresistible in its elegance and beauty, evidenced in cases such as Nerve, McEwan, and Bisram. In a broad sense, the narrative goes something like this. The socio-historical and colonial context out of which Anglo-Caribbean independence constitutions have emerged demand a privileging and prioritizing of human rights in the interpretation and application of all laws. That is, the conjoint effects of the principles of constitutional sovereignty and supremacy. As such, and generally, intra-constitutionally, if there is a tension between constitutional provisions, human rights values prevail. Interlegislatively, the same applies, and as well in relation to all actions, decisions, and behaviors of public bodies, agencies, and authorities. This jurisprudence is a right-centric approach that has been described as chiastic, with cascading and ripple effects throughout the entire legal order. Solomon Marin. Grounded in the socio-historical reality of Caribbean history and the struggle for sovereignty, this CCJ approach can be described ideologically and unapologetically as a contextually shaped post-colonial legal methodology. Significantly, the UK-based Apex Court for the Caribbean, states that still utilize its services, the Privy Council, has been unable to imagine such an approach, steeped as it is in its own Zits and Laban of empire, coloniality, and parliamentary supremacy. Its most recent examination of the General Savings Law Clause conundrum in relation to laws that undisputedly infringe human rights acknowledges the coherence of the CCJ's core approaches as, and I quote, tenable arguments. Chandler, yet conveniently relying on the doctrine of stare decisis and a deference to parliamentary supremacy, it upheld the constitutionality of these colonial rights derogating laws. That's the Chandler decision. What the astutely incremental approach of the CCJ enables, in comparison, even if it is at times hesitatingly so, is the hope of all peoples of the Caribbean for the good life as envisioned by Professor Simeon McIntosh. That is, for societies anchored in a constitutional, democratic and rule of law legal framework in which human dignity, rights, and individual autonomy coincide with participatory democracy, fashioned by Caribbean identities and realities and its people's unique aspirations for self-determination, rather than colonial legacies. This McIntoshian good life is one in which the Constitution is at the heart of governance and the legal order, and serves as a social contract that balances power, promotes human rights, protects fundamental freedoms, and ensures meaningful and relevant justice for all. Professor Tracy Robinson, whom we will soon hear from, gives Caribbean embodiment to the Einsteinian insight that imagination is more important than knowledge. In Our Imagined Lives, she dares to imagine what she describes as, and I quote, the shapes of women's imagined lives. She does so in terms that give practicality to McIntosh's more theoretical formulations of the good life, and which are poignantly opposite to our explorations today on social and economic rights. And I quote, here's what she says: I am speaking of full lives with all their complexity and tentativeness, not identical ones or perfect ones. Included would not just be our need for the basic resources for health, physical sustenance, and shelter, for decent work and freedom from violation. Also included would be our interest in emotional well-being and development, community and connection to others, and separateness too at times, leisure and play, spiritual bonds and space, and the capacity to exercise our imagination and to reason. Indeed, this vision of the good life and its imagined articulations are very much at the heart of the mandate of the CCJ. And I quote, to have a determinative role in the further development of Caribbean jurisprudence through the judicial process. And that's taken from the preamble to the agreement establishing the CCJ. Largen and Supal, a 2004 decision of the CCJ, is a very recent example of how the CCJ is living up to this responsibility and imagining the good life for people of the entire Caribbean. Majority of the court stated, and I quote, the constitutional ground norm of human dignity, when linked to the right to life, has led to the development of the right of all persons to a dignified existence, a life of dignity. With this entitlement comes the concomitant duty of all arms of the state, including the judicial arm, to facilitate it. Citing the IACHR decision in Street Children versus Guatemala. Placement of a right to a dignified life at the center of human rights is itself a significant step in advancing a case for the constitutional recognition of social and economic rights. We may describe it as a step towards progressive realization of the justiciability of these rights. Colloquially, in the development of this post-independence Caribbean constitutional common law, we spin in, we on top. This is not just decolonial constitutionalism in operation. I suggest it is something much, much more. It is in fact a contextually informed reimagining of legal methods and approaches designed to give effect to the new legal orders intended through Caribbean constitutionalism, and in so doing, to the hopes and aspirations of the people of a region. As we celebrate these legal advancements on this, the 20th anniversary of the CCJ, we must also face the next frontier, the adjudication of social and economic rights. A challenge that is already unfolding in Caribbean courts, as we will hear soon enough. For communities whose ancestors were victims of slavery, indentureship, and First Peoples genocide, and for whom housing, health, food, and education were virtually denied, and when enabled, provided at subhuman levels. An inexplicable irony is the general regional hesitancy, legislatively and jurisprudentially, to recognize normatively and give clear constitutional status and effect to social and economic rights. We will hear how things are changing, but are they changing fast enough? The burning issue that we will continue to be called on to confront as our regional futures unfold, therefore, is and includes, should our courts be empowered to adjudicate on social and economic rights? And if so, to what extent? Or are these matters completely off limits for the judiciary? The CCJ, as a regional apex municipal court, will, I believe, have to assume leadership roles and sort out several tensions. For example, the tensions between positive rights versus policy, separation of powers versus guardianship of democracy, and also concerns about, among other things, representative democracy, expertise, forum suitability, and the vexing question, the vexing Caribbean question of good faith and conscientious interinstitutional relationships and commitments to a right-centric governance. If the courts are guardians of democracy, then why should these matters be off limits? And if human rights are interdependent, interrelated, and indivisible, grounded in human dignity, what informs the hesitancy around social and economic rights? Indeed, is there any special value of constitutional adjudication in relation to these matters? These are among the issues that we want to explore together today. And so as we mark this milestone, let us both celebrate the past 20 years of the existence of the Caribbean Court of Justice and at the same time commit ourselves to shaping our future. We are the ones who must mold our destiny. Judiciaries have a part to play step by step in increments. May I say sometimes a hop, sometimes a skip, and sometimes a jump, even a leap. They do so by continuously developing the law in relevant ways responsive to changing Caribbean norms and social realities. Law and society are, after all, inseparable. And so congratulations to the CCJ on its 20th anniversary. May its jurisprudence continue to grow from strength to strength and play its part in service of Caribbean democracy and sovereignty. Thank you to Professor Jeff King, to Justice Westmin James, to Professor Tracy Robinson and MonaLaw. Without you, this program would not have been possible. And thank you to the support personnel of the CAJO, MonaLaw, and the CCJ, who have brought to bear their talents and enthusiasm to ensure that what we experience today is of the highest quality. Welcome to everyone. Let our conversations begin in earnest. Welcome again.
Thank you very much, Justice Jamadar. Good afternoon, evening, or night to you all. The teacher in me wants to wait to hear back from you in response. Good evening or good afternoon too. But I wanted to join in welcoming all of you. First, on behalf of our Dean at MonaLaw, Professor Shazida Ali, and also our Associate Dean, who is with us on Zoom, Dr. Celia Blake. We're very pleased at MonaLaw to be co-hosting this discussion with CAJO, and particularly in celebration of the 20th anniversary of the Caribbean Court of Justice. And this is for us the second in the Caribbean Public Law Dialogue series. We're pleased to have judges of the CCJ with us. And I note the comments of current president, the Honorable Mr. Justice Adrian Saunders, who a decade and a half ago talked about the change in role of judges. He anticipates some of our discussion about adjudication of social and economic rights. I recognize in the room today Justice Rajnath Lee, a judge of the CCJ, and there may be others who are online as well. But there are also many other judges, both in the room and online, and we welcome you. We see our judges of appeal in Trinidad, Tobago, in the Bahamas. I see Chief Justice George of Guyana with us. I see Chief Magistrate Anderson of Bermuda in the room with us. I'm grateful that you have joined us, and court officials as well. As we focus on the human rights that ensure we have the conditions to live a dignified life, or at least a minimally decent one, we take note of the recent unequivocal support for constitutional, social, and economic rights from 2 constitutional reform processes in the Caribbean. We give thanks to all of you who shared your many questions and comments with us ahead of time, some of which we shared at the top of the program, but all have shaped what we're going to do this evening. Our background note makes the point that most Caribbean states have long acknowledged that social and economic rights are human rights by ratifying the Covenant on Economic, Social, and Cultural Rights, Barbados as early as 1973. And while English-speaking Caribbean states have been ambivalent about the justiciability of constitutional, social, and economic rights, we have almost all declared that social and economic justice are fundamental pillars of our countries and our constitutions. Right after me, you're going to hear my former colleague and good friend, the Honorable Mr. Justice Westmin James, give us a brief overview of what we have now in respect of constitutional, social, and economic rights. Justice James, who is known to many of you, sits on the High Court of Trinidad Tobago and has acted on the Supreme Court of Belize and the High Court of Barbados. He has an extensive discussion on social and economic rights in the 2020 Oxford Handbook on Caribbean Constitutions, and he's also a co-author of a book on the referral procedure under Article 214 of the revised Treaty of Chaguaramas. The rest of the roundtable discussion is going to be divided to give you a sense of what comes next into 3 parts, ending with a discussion that includes you. Part 1 looks at why do social and economic rights matter, and also why constitutional social and economic rights. Part 2, how can we design constitutional social and economic rights? And part 3, how do we adjudicate constitutional social and economic rights? For those 3 parts, we have the pleasure of talking to our very special guest, Professor Jeff King of UCL Laws. Several in the region involved in constitutional reform met him last summer in Oxford, talking about his ideas in his masterful and award-winning Judging Social Rights. Thank you, Professor King, for spending your afternoon with us across 20 Caribbean states and territories, some judges, many attorneys, some human rights defenders, some law students from several institutions, some of us academics, and most of us just plain curious or interested in what may be good reasons for designing constitutional, social, and economic rights, and what should courts do in adjudicating these rights. Professor King is the Deputy Director of the Global Center for Democratic Constitutionalism at UCL. He was the co-principal investigator for a global project on national responses to COVID-19. Among many other things, he has served as the Director of Research at the Bingham Center for the Rule of Law, and not unimportant, his faculty, UCL Laws, has for decades supported graduate education of Caribbean lawyers. Before handing over to Justice James, I just want to say again, thank you all for joining us, and grateful, Ishmael, if you could share some of where some of us are from, which have been shared with us in the Mentimeter. So I know Gabrielle Elliott Williams was encouraging the non-Jamaicans to speak up, and you can see both Trinidad and Tobago and Jamaica well represented. I can see less well from where I am, but I have a sense that we have participation from many Caribbean countries, and we're grateful you are with us today. Thank you very much. I'll hand over to you, Justice James. You're muted for the moment, Westmin.
Yes, thank you very much, Professor Robinson, and welcome to everyone, and it's lovely to be here. My task this afternoon is really to give a brief overview of where we are in the Commonwealth Caribbean in relation to socio-economic rights. So I can pave the way for Professor King to give his talk. So as we all know, social and economic or socio-economic rights are a category of human rights that ensures individuals and communities have access to the basic conditions necessary for a dignified life and full participation in society. These rights include, but are not limited to, the rights to work, the right to fair wages, social security, an adequate standard of living, health, education, and housing. Socioeconomic rights are recognized not only domestically, but under international human rights law, particularly Universal Declaration of Human Rights, the International Covenant on Economic, Social, and Cultural Rights, and within the region, the additional protocol to the American Convention on Human Rights in the area of economic, social, and cultural rights. Socioeconomic rights impose both positive obligations on states to take proactive measures for their realization and negative obligations to refrain from actions that undermine them. Unlike civil and political rights, which are often seen as immediately enforceable, social and economic rights are subject to what we call progressive realization. So states must take appropriate steps to maximum of their available resources to achieve their full realization over time. In legal discourse, as we would see today in debates, the debates persist regarding its justiciability and the appetite for courts in the region for interpreting and enforcing these rights, particularly through constitutional and regional human rights mechanisms. So social and economic rights are located within the Caribbean Constitution from a sliding scale of prominence, whether it be in the preamble to the opening section to the Bill of Rights in those jurisdictions that have one, and more limited textual anchoring within the detailed section of the Bill of Rights. This, with the exception of Guyana, whose constitution contains the most socioeconomic rights in the region, I will explain. So firstly, 8 of the 12 independent Caribbean states contain preambles that refer to social and economic entitlements as aspirations of we, the people, and essential to a just society. You can see it in Antigua and Barbuda, Barbados, Belize, Dominica, Grenada, St. Lucia, St. Vincent and the Grenadines, and Trinidad and Tobago. A few examples. Grenada's preamble says, whereby everyone may enjoy his economic, social, and political, civil, and cultural rights. St. Lucia, enjoyment of an adequate standard of economic and social well-being dependent upon the resources of the state. Trinidad and Tobago, respect for the principles of social justice, and therefore believe that the operation of the economic system should result in the material resources of the community being so distributed as to serve the common good, and that there should be adequate means of livelihood for all. Such concrete references within the preamble of the constitutions have not resulted in strong protections of socioeconomic rights. And this, of course, turns substantially on the enforcement of the preamble within constitutional theory because of our constitutionalism. We have seen in Joseph and the Attorney General where the CCJ through Pearl with Justice Witt characterized the preamble as filling the Constitution with meaning and breathing life into the clay of the more formal provisions of that document. So preambles have been an important source for implying, as we know, the rule of law as an unwritten constitutional principle. However, the courts have not yet found that the provisions are directly enforceable in our constitutional setting. In our Bill of Rights, there are a few direct references to socioeconomic rights within the Bill of Rights. The most litigated social and economic right is that of the right to work. You can see the right to work mentioned in the constitutions of Belize, Grenada, Guyana. In particular, the one in Belize, where the right is expressly guaranteed in the Constitution, that has given rise to litigation. We can see cases such as Wade and Roaches, where an unmarried female teacher who was dismissed because she was pregnant and unmarried succeeded in establishing a breach of her right to work, as well as her right to non-discrimination. We also have seen the right be looked at in the case of Fort Street Tourism versus the Attorney General, as well as by the Caribbean Court of Justice in Lucas and another versus the Chief Educational Officer. In Lucas, the CCJ looked at the scope of the right, which they held was the opportunity to work. They held that the extent of the right varies from country to country, dependent on a state's economic well-being. The CCJ accepted that the right to work is not a guarantee of employment, but merely an opportunity to earn a living. They held that there can be no legislative or administrative fetter or regulation placed on that right. The Belize Court of Appeal recently considered the right in the Control of Supplies versus Gas Toma, a decision that is currently on appeal to the CCJ, where Justice of Appeal Balkan noted the cases, particularly the CCJ's Lucas versus Chief Educational Officer, and emphasizes that the Constitution guarantees the opportunity to work. He identified as key elements to that right the opportunity to work, not actual employment. The opportunity is one freely chosen field. C, no fetter should be placed on the right by the state, whether by way of law or administrative action, which hinders the free exercise of the right. Such fetters are objectionable where they are unjustified. Beyond the use of the strict text, where right to work is protected, implying the right to work within other rights is more fraught terrain, such as the right to life, which has been used in other jurisdictions, has been rejected thus far. The right to education, socioeconomic right to education, has been constitutionally recognized in only a few Caribbean jurisdictions. We can see so in Jamaica in Section 13K of the New Jamaica Charter of Fundamental Rights. We can also see it in the Guyana Constitution, and in Trinidad and Tobago, there is the right to choose. I just want to make sure that I'm keeping within time. So the constitutions from 4 overseas territories, Cayman Islands, BVI, Montserrat, and Turks and Caicos, also contain the right. That right has been not as well litigated, but it can be seen in a couple cases of Sumaya, Mohammed, and Maureen from Trinidad and Tobago, as well as Jagasar versus the Teaching Service Commission. The right to a healthy environment has been included in the constitutions of Guyana, Jamaica, and 3 of the 4 new overseas territories constitutions. And that right to environment is also included in the Protocols on Foundation. The socioeconomic right to ensure the highest attainable standard of physical and mental health, including access to care, nutrition, and clean water and air, can be seen to involve both physical and environmental protection. The Constitution of Guyana provides a constitutional right to free medical services, and under Article 25 and 36 provides that every citizen has a duty to participate in activities designed to improve the environment and protect the health of the nation. Among others, Jamaica Charter of Rights provides for the right to enjoy a healthy and productive environment free from the threat of injury or damage from environmental abuse and degradation of the ecology heritage. 2 cases which the right to health and protection of the environment through the right to property were given to effect. It were the cases of Carl and others versus the Attorney General of Belize, and Maya Lyons and others versus the Attorney General of Belize as well. I wouldn't go very much into it just to say that in those cases, the CCJ significantly not only used the right to protection, but the fact of security of the person and the protection of the law to guarantee certain these particular rights. The right to housing has been considered to ensure access to a safe, secure, habitable, and affordable home with freedom from forced eviction. There is no explicit constitutional anchors for this right as such, but the right to housing currently can only be protected by drawing analogies to certain civil and political rights, mainly the right to privacy, right to property, human dignity, and the prohibition against inhumane and degrading treatment, which has not yet been utilized within the Caribbean. The recognition of social and economic rights in the Guyana Constitution has been the most extensive and complex guarantees of social and economic rights within the Commonwealth Caribbean. The social and economic rights are dealt with in three parts in the Guyana Constitution. In Chapter 2, where it provides that the right, it includes the right and the duty to work, the right to leisure, the right to medical attention and social care in old age and disability, the right to housing, and the right to attention and education. And that makes it a duty under the Article 39(1) that the courts, all public agencies, are to be guided by the principles in the discharge of their functions, and empowers the Parliament to provide that these principles are enforceable in a court or tribunal. There's been no clear approach thus far, but there has been early encouragement to take Article 39 seriously. Besides that, there is, in Guyana's 1980 Constitution, we retain an aspect of the protection of fundamental rights and freedoms of the individual. And within that, the protection of human rights added in the Guyana Constitution in 2003 guarantees to persons in Guyana the human rights enshrined in 7 international human rights treaties, including the ICESCR, and persons in Guyana have the benefit of these treaty rights only if these rights are not covered by Title I. Because the latter is excluded from the purview of Title 1A, as a result, the directly incorporated treaty rights are most likely to be the social and economic ones that fall outside of Title I. The executive, legislature, judiciary, and all organs and agencies of government are required to respect and uphold Title 1A rights, and the state must take reasonable measures within its available resources, having regard to its social cultural level of development to achieve progressive realization of these rights. Now, redress for these rights must be sought through the new Human Rights Commission, which Guyana has been slow to establish, and further limiting the possible impacts of Title 1A rights. The survey of socioeconomic rights in the region demonstrate somewhat weak protections of these rights, with limited enforceability as it relates to justiciability of such rights, anchoring such claims within the strict text of the Constitution. Even if the concepts of socioeconomic rights drive aspects of the development agenda, in the absence then of concrete and justiciable groundings and constitutional entrenchment of economic and social rights in the Commonwealth Caribbean constitutions, the extent to which evolving human rights jurisprudence can play a role in the interpretation of domestic law or could be directly applied by judges is an important framework within which the rights interpretation can be situated. And I will point out to the cases of the Maya Alliance by the CCJ, where they grounded certain aspects within international law, which I'm sure we will discuss later on as well. And finally, I want, because I know time will run out, that the Guyana scheme has produced very little litigation. And what I would like to look at, or just stress simply, are judicial approaches which have emerged in our Commonwealth Caribbean Constitution interpretations adequate? The Guyana scheme has produced very little litigation, and the directive principles do not seem to be taken into account much by the judiciary, despite Article 39(1), which puts courts on their duty to be guided by the directive principle. The second, I think, is the unwillingness to consider if any social and economic rights are implied from existing rights, and using the Indian model and the Inter-American approach, which is more expansive. Some movement can be seen in the CCJ, in CAL, and I would like to also mention the more recent decision of Lamkin versus the Attorney General of Trinidad and Tobago. And in that case, the court had to was asked to determine whether the scope of the right to life, the right to the protection of the law, and the right to respect for private and family life encompasses a positive obligation on the state to take effective action to protect victims of domestic violence and their families from violations of their fundamental rights at the hands of perpetrators. The court adopted an expansive interpretation of the right to life, having regard to Commonwealth and international jurisprudence. This might be the beginning of the use of the right to life as a gateway to the protection of the socioeconomic rights within the region. I'm sure I went over my time and apologize, but just to give a brief framework of what we are going to be discussing this afternoon. Thank you.
Thank you so much, Justice James. You did offer us many opportunities to think about how more might be possible. As we go into part one, I wondered, Ishmael, if you could just share where those who are joining us are from. We know we're a little bit further away from the YouTube audience, and so I just wanted to see where we're from. If you could just share that for a second with us, Ishmael, before we begin. From what I could tell, we were mostly younger attorneys. So it's the second one, Ishmael. Excellent. So my sense is, and so you'll notice I'm looking down where I can see a little bit better. So I have a sense many of us are young attorneys, which is interesting. We have judges here, as we know. We also have many senior attorneys here as well. And we have students. We have civil society leaders, I noted from SASOD in the chat, and other organizations. And we have academics and lecturers. I know the LLM class in International Human Rights Law has just joined in. So we have more of the MonaLaw community joining. Thanks very much. I wanted to turn to part one and welcome Jeff King again. And Jeff, so some have met you and many haven't. And your book, Judging Social Rights, uses the United Kingdom as a case study. But the minute you open your mouth, folks will realize you're connected with other places. And I wondered if you could just tell us a little bit about your background and why the Commonwealth, which we are mostly a part of, was so important to this particular project.
Thank you, Tracy. And I want to begin by saying how much of an honor I regard the ability to participate in this seminar, and also to compliment the organizers, especially you, Tracy, on how professional it is and the way it's put together and the materials that have been circulated. I'm enormously impressed by it. My own background is that I'm Canadian. I lived in Canada until my 20s. And then I traveled. I lived in Korea, the UK, and Ecuador for extended periods of time, and came back to Canada to begin my legal training at McGill in Montreal. After studying at McGill, I became an attorney in New York City. I worked for Sullivan and Cromwell for a year, and then I moved over to England with by then my German wife that I'd met in Ecuador to study for my doctorate in Oxford. And I stayed there. That was 20 years ago. Mm-hmm. And I think in reality now I'm more of a UK lawyer, although I'm a member of the Bar of New York and I have a Canadian law degree as well. And I'm happy to say I was the first foreigner to be appointed as a legal advisor to the Lords Constitution Committee. So it was a nice moment for me being an expat. Now, the Commonwealth is really important to my work because I essentially consider us as part of a legal and political family. There are some very important traditions. I feel the common law method of reasoning, the judicial traditions that have originally flowed from Britain, but across the Commonwealth, the parliamentary system, the electoral system, the concept of an independent civil service, which I know one of the comments in the materials was that's not always the reality in Jamaica, for instance, but it's the aspiration to that as a common feature of our culture. And then the cultural exchange between the different Commonwealth jurisdictions. And I really feel that strong cultural connection. I've observed it in my teaching at UCL and in Oxford before that. Students several from Jamaica, but also from India and Sri Lanka and Pakistan. I feel that we speak a common juridical and political language, even if the sort of level of income in the countries is quite different. It's less different as time goes on, I have to say, even in my lifetime. But those commonalities have always struck me, and therefore I felt confident both prescribing recommendations for other Commonwealth countries and indeed following the approach in South Africa, which is an upper middle income country, to recommend that the UK follow that approach.
Thanks so much, Jeff. I wanted to turn to the start of your book. So the very beginning of your book asks, what is more important? And I'm going to Caribbeanize here a little bit and say, what is more important? Freedom of speech to criticize your governments, freedom of speech to express our distinctive cultural practices, or ensuring we have a fighting chance to finish a high school education or to receive health care for very treatable illnesses. You assume that the audience already accepts that these are rights, even though we have just heard our constitutions are more muted in respect of them. And north of us, we don't hear about it much at all. We hear about civil rights. Can you just say a little bit about why you think social rights matter and your idea that there are some core interests that, to quote you, give rise to claims for resources for a minimally decent life?
Indeed. I have to say that if I had to write the book again and compare the importance of dancehall and reggae to social rights, the rhetorical effect of that bid wouldn't have been as powerful because they're not obviously more interesting or important. But I think the point essentially stands. And I'd like to answer your question by actually referring to some slides, because I think there are legal arguments for why social rights are human rights. And then there are matters of political justice, and then there are even pragmatic reasons to consider them social rights. So if Ishmael will allow me, I'd like to share my slide deck here. It took me a moment to find it, as I have dozens of windows open at any point in time.
As do we all, Jeff.
Indeed.
We'll give you a second.
Thank you very much. I think this is the one. Yes. I just want to put it here. Great. So, why are social rights important? Why should we consider them to be fundamental rights? Well, the first is that they are an enormously significant feature of international law. So I've here listed the primary international legal instruments that make reference to or provide a very strong role for social rights. And as you can see, they are located throughout the global or international UN-led system of human rights protection. The International Covenant on Economic, Social, and Cultural Rights is but one instrument. Most that followed also make space for social rights and reflect the idea of indivisibility of civil and political and social rights. Regionally, there's also a list of instruments here that recognize the importance of social rights. So one answer to why they are important is that they have been recognized as such and need to be taken seriously in the body of international law that applies to states. We are lawyers, and most of our governments have ratified one or more of these conventions. That's one reason. Now, that's probably not the sense of the answer you wanted from me, so I wanted to address the question from the perspective of political justice and the normative arguments in favor of the idea of human rights, social rights. Now, if we start with the understanding of human rights as being political claims against the state and other members of our community that have a fundamental importance that should be given importance above other kinds of policy claims, generally speaking, then we'll need a theory that identifies what a group of such claims would be. And there are a number of theories that have been offered for all of human rights. Dignity is one such value. It is considered the foundational value for the recognition of human rights. It's stated as such in the Universal Declaration of Human Rights, and it's invoked by a range of philosophers and statespersons. The idea that one could live a dignified life without a basic social minimum that is a provision of resources or opportunities that allow people to frame and pursue some form of good life that they can play some role in designing. The idea that one could live in dignity without such provision is plainly false. I think one of the comments by a perceptive student in reply to your questionnaire pointed out just this very argument, and I agree with that student, and I think the international community agrees with it. Another argument is that human rights are essentially claims to be treated equally, to be shown equal respect and concern. Well, most theories that are based on a notion of equality need to have a theory of distributive justice that is a part of their theory. So if we take a theorist like, say, Ronald Dworkin, the American political philosopher, or John Rawls, for both of whom equality figures very prominently, they each have highly developed theories of distributive justice. And with Rawls in particular, there is an account of social welfare rights in his work, especially his late work on political liberalism. Liberty is, in most philosophical accounts, concerned with autonomy. It's the capacity for people to form and realize their own self-identified goals. For both of those aspects, both forming and realizing those goals, the provision of a social minimum that includes resources to be provided with an element of education, to not have to work constantly, to have some moments for self-reflection, and of course, to be able to plan one's life to realize these goals. In other words, in order to achieve autonomy, you need to have a social minimum in place. Any writers on autonomy are very clear at pointing that out. Some people are attracted to the idea that they're utilitarians. They think theories of rights are correct only if they produce more aggregate welfare than other political systems, and they have utilitarian theories of rights. That sounds silly probably to some, but there are such theories out there. Well, a social minimum is about the most basic unit of well-being. A social minimum, as I've discussed in the book, is a bundle of resources to ensure a socially minimally decent life, is essentially designed to identify the conditions beneath which life is fundamentally intolerable. So if your theory of rights is based on welfare or well-being, the idea that social rights should figure in that theory is pretty clear. And lastly, some think that rights should be understood as instrumental to democratic government. And they think, especially in the last 40 years, there's been a lot of emphasis in political theory on how there's so much disagreement about what values are, that what we should focus on is the creation of conditions under which we can make political decisions, in which we can settle those disagreements that we can't resolve by pure reference to philosophy. So we should have deliberative democratic systems where people can participate on a free and equal basis and contribute their voice to the discussion of what something like equality or liberty means. Well, if that's the theory that supports your rights, you'll have to recognize that a social minimum is required to participate effectively in that kind of discussion or discourse. And so in the book, I suggest that, whatever the basis of your theory of rights is, if it's one of these 5 things, you're going to be recognizing social welfare rights. They are fundamental to human dignity, equality, liberty, well-being, and to democracy. That's from the point of view of normative political theory, but just on a purely pragmatic basis, let's say you don't care about any of those things. Why should I care that social rights are human rights? Well, here's a few items. In an extremely unequal society, there is going to be greater personal threats to one's welfare and one's family's welfare, crime, personal safety. People who've been in such scenarios will know this. They will recognize it immediately. Social stability, it's not just about whether someone's going to break into your home, but it's about, you know, whether businesses are going to collapse constantly, or the transport system will break down, or there will be riots, etc. It is very difficult in extremely unequal societies to have a measure of social stability, which is often needed for planning your life. Similar for the rule of law and corruption. It's hard to maintain a society that is committed to the rule of law and is not seeking to use corrupt methods to bribe public officials or other private bodies if the level of deprivation is so great that one feels they have out of desperation to try these kinds of things. It's harder to maintain the rule of law. It's not impossible. The link between inequality and the rule of law performance and the indices is actually not straightforward. If you did a simple bivariate comparison of how unequal are you and how poor is your respect for the rule of law, they don't align perfectly, but they are related to one another. And lastly is economic growth. All those libertarians and neoliberals, well, they're interested in the rule of law because of this kind of thing, but it is also very difficult to sustain economic growth if the social fundamentals in your society are broken. And so for all these reasons, I think we need to recognize social rights as human rights, and it takes us around to the question of whether that recognition should go into the Constitution or not. So I'll pause that for now.
Thanks so much, Jeff. You know, I have a question about the COVID-19 project, but I'm going to hold it.
Sure.
And maybe in the Q&A, we could come back to it, because I want to follow on by asking you about what you consider good arguments for being skeptical about constitutional, social, and economic rights. What you don't consider to be particularly good arguments. We often hear a fairly flat set of argumentation about why this is simply not worthwhile. But you actually distinguish between the two of them. And if I could ask another question on top of that one, which is, what do we have to gain, in your view, from considering placing these rights in our Constitution in a way in which courts can adjudicate?
I'm going to go back to this set of slides, actually. Thank you for that question. So, this should be about the judicial enforcement of social rights. So I do distinguish between what I consider the weaker arguments against the judicial protection of social rights in order to actually help us identify the good ones, because sometimes when these arguments are presented, people say, well, that's all nonsense. And then they think that they've made the case for justiciable social rights and that there are no good arguments against them. And I think that there are some good arguments about the dangers of being cavalier about judicial enforcement of social rights. And I'll explain those as we move on. Now, some of the weaker ones are this older one, that social rights are not human rights. And I think that it hasn't disappeared entirely. You could say that it is instinct in some of the way the constitutional framing in the Caribbean has functioned. And you have a similar constitutional framing in Ireland and India, where the social rights provisions are in non-justiciable portions of the Constitution. Well, as we've seen, the international human rights law framework pretty much puts this argument to rest. Another argument is that courts cannot adjudicate policy questions, but we know from private law, we know from other areas of public law, that courts frequently adjudicate policy questions. And I have a statement in the book that Ronald Dworkin's attempt to deny that judges decide policy matters is one of the bigger dead ends in jurisprudence. And that's a fairly broad, widely held view. Another claim is that courts don't enforce positive rights, but there are dozens of examples in constitutional law across the Americas and Europe where judges have enforced positive obligations, which is not to say that they are not problematic in some cases, but this argument stated this baldly just doesn't really work because there are far too many counterexamples. Another is that social rights are too vague. What does it mean to say that someone has a right to health care? Well, much of administrative law and private law and ordinary constitutional law involves the adjudication and enforcement of very vague terms. So if we were to have to get rid of concepts such as reasonableness in private law or freedom of expression in constitutional law, and there are many, unfair dismissal would be another, we would have to radically change our legal system. So stated in such a fashion, I don't think it works. Now, that it would violate the separation of powers, I want to be clear, I want to be careful here, because I realize this is a very important juridical principle in the Caribbean and in the jurisprudence of the Caribbean Court of Justice, so far as I understand. The issue about when this is used in the social rights context is that typically the argument goes in one of two ways. First of all, that to enforce social rights would violate the separation of powers because it is the province of the legislature to allocate resources in the society. And courts need to respect that and stay away. That's version one. Version two is it is the function of courts to protect rights and under the separation of powers, and social rights are rights. They are human rights. So where do we go with these two contradictory conclusions? I think it's not so helpful to think about it in that way. One might conclude after a more substantive analysis of the kind of factors I'll look at in just a moment, that what has been traditionally regarded as a theory of the separation of powers suggests that some kinds of social rights issues should not be adjudicated. That's absolutely, I think, a fine and appropriate use of the concept. But when it's just trotted out in this format, I don't think it works. The other claim that one meets, especially from philosophers, is that it's hard to call social rights rights because they demand resources. You can have rights in conflict. But I think in any legal system, there are many values that come into conflict, and they need to be balanced against one another. And balancing is a central function in constitutional adjudication. The Germans have really theorized this to the full hilt. And how they balance competing interests. But any judge who's carried out a proportionality analysis will have some sense of how balancing is part of the ordinary function of the judge. So I don't think these work particularly well, but let's move on more sympathetically to some arguments that do make sense, and I want to explain why. So democratic legitimacy. Since social rights entail the allocation of resources, it's particularly in that field where legislatures have historically played a very important constitutional role. Taxation without representation. The House of Commons has always enjoyed a privileged position, literally a privilege. It's called the financial privilege. I don't know if it's the same in Caribbean constitutional practice, but I suppose it probably is, that the lower house will have privilege in financial matters. And of course, if you're talking about the distribution of the revenue to a multitude of claims, there is something about legislatures which allows people to speak and complain and jostle for a particular allocation. And we don't do well to ignore that and saying simply that social rights are rights, because there are other interests that are very important that will also compete for those resources. So I believe democratic legitimacy is important. Polycentricity. I don't want to go all the way into the depths of legal theory here, but this is an idea that the American legal theorist Lon Fuller made popular. And essentially, it is about the kinds of issues that are very complicated and bound up with other kinds of issues. So a polycentric issue is one where there's a network of relationships that is connected to other large networks of relationships. So if you could think of setting the price of a commodity, that is a polycentric issue. What price should milk be in a particular society? Well, it depends on production, depends on transport, depends on trade, depends on weather, it depends on what substitutes could exist for milk, and so on. And so to try to determine that one issue in isolation from considering all of the others is difficult. Now, the reason that Fuller concentrated on polycentric problems is he said, adjudication by its nature is a process in which two parties come to court and talk about their problems. And in polycentric issues, there are many unrepresented parties that are not before the court to make their case. And he thought that resource allocation on a nationwide level is the polycentric problem par excellence. And so there's something to this. And I don't deny that. I think it's a pervasive feature of adjudication, but there's something here. It should be taken seriously everywhere in adjudication. Expertise. If we think of COVID-19 and the kinds of legal challenges does the state need to have a stay-at-home order to pick that policy? There were legal challenges everywhere. Most of them were unsuccessful, and I think they should have been unsuccessful because the decision about whether a stay-at-home order was necessary to stem transmission and therefore save many lives is something that in a well-functioning democracy, a health bureaucracy that has health surveillance information, that is in constant dialogue with scientists, and then in discussion with a cabinet with political responsibility, those are the methods in which you'd want to determine something as big as that. And so expertise, especially when it's of a high level macro societal determination, or where you need a collective body of experts to give you a sound view, in those types of cases, there are very good grounds for judicial restraint. And in fact, much of the Lochner period in the United States, which is a period of constitutional adjudication between 1905 and 1936, where the US Supreme Court struck down hundreds of labor statutes and dozens of congressional statutes that tried to build the administrative state. Ignoring expertise was one of the flaws of the court's period, and the reference to the need for expertise was one of the main arguments for the building of that administrative state, which was the welfare state, essentially, or in the early American welfare state. The last argument, which is frequently not looked at, is the need for flexibility. So if you're dealing with complex social policy, if you make a decision at time A that is based on a set of social conditions, and then at time B, those social conditions have changed, it can be difficult to change the law. That is, to revisit the judicial decision. It's not impossible to do it, but some litigant has to take that same issue back up to the court under conditions where an existing precedent is against them. And so if you need to change the policy frequently to adapt to changing social circumstances, making it inflexible through constitutional adjudication can be a problem. Now, Tracy, it might sound here like I've just put the knockdown argument against constitutional social rights. But of course, my book is an attempt to say there's a lot of wisdom in these, but they don't justify excluding social rights from the Constitution. And I can say something about how that argument works, or we can save it till a bit later in the session, because I've been talking for a while.
No, I think we'd love to hear it. And just to say, Jeff, these slides help.
Okay.
I know you were unsure, but I think, it's nice to see the argument presented in this way as well. But I would love to hear, having heard the other side and the good arguments, some are saying, well, there's no good reason. So we'd love to hear some of the reasons why we should.
Okay, sure. Thanks for the comment about the slides. I think I can get a tutorial from Ishmael about presentation afterwards, after this session. So the main argument in the book is that there are benefits to constitutionalizing social rights. Making social rights part of the fundamental, the basic law, the constitutional law of the country is a political signal that these values are as important as any other values in the society. The kinds of things that Donald Trump is doing in the United States right now would be flagrantly and obviously unconstitutional. Well, that's not stopping him from doing other flagrant and obvious unconstitutional things, but it would be even more so to gut an administration like Social Security, or to just drop Medicare like a hot potato. And there are some countries where these things are political impossibilities, and it's partly because the society is collectively committed to a set of values which take those kinds of options off the table. They don't always have to be inscribed in constitutional documents. In the UK, the commitment to the National Health Service is of a quasi-constitutional character. But in some cases, an explicit constitutional commitment does assist. This exists in Denmark, in Finland, in Germany, and in other countries, where you start with a commitment to those ideals. And that doesn't mean that it is for the court to decide on the complete character and every last duty that follows from that kind of commitment. It's not uncommon to have constitutional principles which the courts don't enforce in their entirety. Some call this under-enforcement of constitutional norms. There's an essay by Larry Sager, an American constitutional lawyer. But there are others, such as the Regional Disparity Clause in the Canadian Constitution, which talks about an obligation for there to be interprovincial redistribution. That's not something that is expected, that would be enforced by courts. There are provisions relating to Aboriginal persons' rights in Canada. Similarly, there is an Aboriginal rights jurisprudence in Canada, but it's not located principally within the Constitution. And in Germany, there is a commitment to Germany as a social, federal, and rule of law state. And that social state principle is something that is referred to the courts fairly often, but it's not enforced as a plain subjective right. That is a right that individuals would take their cases forward. So there can be a role for courts to hear claims, but the thought that since it is put into the Constitution, it is therefore for the courts to tell us what the full scope of the protection is, I don't think that follows. I think that's erroneous. Now, I'll say a bit more on what I think the benefits would be over and above the political ones as we move into constitutional adjudication. For the moment, I want to talk about how these arguments that I've mentioned don't justify complete non-justiciability. So we'll take democratic legitimacy as one of these arguments. Now, the argument doesn't apply, so far as I can see, in two important situations. One is where the legislature hasn't focused on the issue at stake. Now, I don't think that judges should be going, that the legislative scheme has to be absolutely plainly addressing the very issue that comes before the court. I think that's a recipe for too much litigation. But I think that when one looks at statutes and looks at the kinds of cases that are brought, you get a sense whether the issue is in a class of claims that the legislature either addressed either implicitly or explicitly when it framed the statutory framework. There are a large number of cases where they just haven't. The issue that comes to the court, although it relates to the validity of legislation, the issue is not one that has been considered by the legislature. And I think that one can frame remedies that will address this particular. I call it absence of focus. The other is, of course, the familiar one that when persons are from a group that used to be called discrete and insular minorities, or from a minority group, I chose this phrase here that when people are particularly vulnerable to majoritarian bias or neglect, and they're from a group like that, and when you look at cases that come to the courts, in most cases you can tell pretty much right away whether someone falls into this category or doesn't. Then where they do fall into that category, I think democratic legitimacy is not a particularly strong argument for judicial restraint. On the other hand, a lot of cases are taken, especially these cases, challenging the validity of stay-at-home orders. They're often not taken by people who are in any way coming from a social group that's vulnerable to majoritarian bias or neglect. They're just disgruntled persons that don't like the policy. And I think democratic legitimacy is a valid ground for courts to be wary of persons taking claims, challenging legislation where they're not vulnerable to majoritarian bias. They're like me in the UK, for instance. I don't think I should be winning those kinds of claims. Polycentricity, oh, pardon me. Yeah, here we go.
Sorry, that was me.
Oh, sorry. So not all social rights issues are especially polycentric. They can be many social rights issues arise deeply embedded in a statutory framework, and I'll come back to that a bit further on. But the issues that arise are much more limited and connected to a particular part of a statutory framework or a system of social provision. In some cases, there are also what I call attenuating factors. It might be that the remedy that is asked for is quite flexible. So they might ask purely for declaratory relief, which gives a lot of latitude to the administration to adjust. It could be that due to interventions, that the court has more information than it might in sort of bilateral adjudication only. Or it might be that there's a particularly strong constitutional mandate to adjudicate that issue that can relate to how specific the text is on a particular social right. And I'll come to that, an example of that soon. And expertise, so I mentioned a few examples in my discussion. There are some areas of expertise which call for strong deference, and what I call collective professional expertise. That's when you have a body that aggregates expert views, like the National Institute of Clinical Excellence on healthcare rationing in the UK, or the vaccine safety groups, which put together a body of experts. There might be 40 on them, and they decide collectively on these things. When you have that, I think there is a very strong grounds for deference for expertise, or where there's a substantial uniformity of social science evidence, similarly. But these are not always the case. Sometimes the expert judgment might be a single expert's judgment. It might relate to a case which pertains to a fairly small amount of circumstances. It's not going to upend national policy. And sometimes there are cases where the government's position is demonstrably flawed by reference to its failure to follow expert advice. And there are some cases I have given in the book, a very famous case in South Africa called the Treatment Action Campaign, where the government had ignored the advice of scientific experts that the antiretrovirals that were being offered free of cost were refused by the government. They weren't actually made available to people, as is part of the South African AIDS denialism back at the turn of the century. Lastly, flexibility. It's true that we need remedial flexibility to adapt to changing social circumstances, but if you're flexible enough with remedies, it could be that you favor procedural rights or declaratory relief, or in some cases, supervisory remedies, which we'll talk about more later. These are techniques that judges can use to accord administrative and legislative flexibility, while at the same time hearing cases, being open to them, and giving remedies in appropriate cases. So I don't think that these principles suggest non-justiciability. And I do think that they're useful, because I know from in the COVID-19 context, where I did support social distancing measures, and I was against challenges to vaccine mandates, that these very principles suggested a judicial restraint in those cases, and I think for good reasons. Okay, I will stop there.
Thanks, Jeff. And let's come back to the question of remedial flexibility. It's one raised by the Trinidad Tobago National Advisory Committee on Constitutional Reform, and we actually have in the room Dr. Terence Farrell with us, who was a part of that committee. So we'll hold that one for a little bit later. We have about 20 minutes, and I'm thinking we'll try and hit some important questions in that time before we open it up a little bit. I did want to share, though, a question we asked the audience. And that question was really, are we satisfied with the social and economic rights protection in existing laws and judicial remedies which are currently available without constitutional reform? And to hear what folks said who are joining us on YouTube or Zoom. And I'm going to ask Ishmael if you're able to just quickly share that before I merge parts 2 and 3 and our discussion together. Is that being shared? No? You can let me know. Yes. And so I'm going to see if I can make the screen bigger for myself. So the question was, our existing laws and judicial remedies are adequate in addressing social and economic rights. We don't need stronger constitutional protection for them. And most people disagreed with that. Some strongly disagreed. We had a few who were undecided and one person who agreed. Thanks very much. Thanks, Ishmael. I wanted to, if I could, quickly ask a question about how we perceive ourselves. You have an idea that countries which protect social and economic rights constitutionally are states that at least have some notion of a welfare state. And I don't think most Caribbean countries that would be part of our identity, even though we have substantial social spending comparable to many places in the global north. Are there multiple arrangements, economic, political arrangements, which admit of the possibility of constitutional recognition?
Oh, I certainly think so. I mean, most of the Caribbean nations are classified as upper middle income by the World Bank, similarly to South Africa and Mexico, the notable exception being Haiti, I believe. So I had certainly that kind of economic scenario in mind. As I said, the South Africa is a country that I think has led the way on a sort of grown-up approach to constitutional adjudication. So when I say in the book that the arguments are aimed at countries that have the foundation of a welfare state in place, it is in the sense that there's a commitment to social spending and giving effect to a system of social policy through various statutory frameworks. And social spending of 26 to 27% of GDP is very good. Of course, we'd have to look at what it's spent on, but that sounds like that's the public welfare effort. So that is, I'm not saying that the social rights of citizens throughout the Caribbean are met, but when I talk about the foundations of a welfare state, I think probably I'm thinking of the bar being lower than what you're describing as existing in the Caribbean. And certainly my experience of scholars coming to Britain to study is that there's an extremely good grounding of education system, and it doesn't feel like there's a huge world apart. Now, I believe Kareth asked a question about what would be the economic.
Yes.
Yes.
So Kareth Kentish, his question was, what does an economy need to look like for meaningful protection of social and economic rights?
Yes. So I'd like to answer that because it's related to the constitutional question, but it's a broader question as well. So I think that what is required to protect social rights meaningfully is a system with a universal system of social protection that ensures medical care to all, universal free primary and secondary education, a system of social security provision which includes old age pensions, social assistance for those who are unable to find work, ideally social insurance for those who lose their jobs, and provision for the sick or disabled who have either lost or never had the ability to work. And those are the three things that the social security should cover. Protecting the right to housing is quite complex. It involves landlord-tenant law, home building schemes, offering shelter to those who are sleeping rough, we sometimes call the homeless, but you can think of the homeless as people who just don't have a home. They might be sleeping in a friend's house or something. a basic system of social protection that will cover those items, will build a legal framework to deal with those kinds of things. Now, I don't think a state has to provide a dignified existence to all of those persons who have interests in respect of those items. It could be highly deficient, but a good faith commitment to the foundations of the welfare state means having a basic legal scheme that addresses all of the above, and a commitment to trying to expand coverage for those social problems over time. My sense is that while it might have gaps in it, the Caribbean nations that I've seen seem to have some provision in many of these areas. And that's the kind of thing I'm talking. Same thing with South Africa. There are serious problems, but at the same time, the basics are there and to be built on. And I'm assuming, statutory frameworks regulating these things, and the provisions of which become the object of ordinary administrative law litigation or cases going to tribunals. So that's what I think you need for a dignified social state that respects economic and social rights.
Thanks, Jeff. I would say the social security is probably what's weakest of the ones you have described in Caribbean countries, some of which many are ranked as, although we don't feel that way, as upper income. A few are not, and a few are a little below. So I'm going to be judicious about my remaining time, Jeff. And you've mentioned South Africa enough times that those listening want to hear more about why you think the constitutional protections there are one way of thinking about how we could go forward in other places like the Caribbean. Could you tell us a little bit more about it? And it is quite significant that for the first time in the Caribbean, or law or constitution reform committees and commissions are recommending justiciable social and economic rights, and they are too looking at South Africa. Tell us what's valuable about the South African model.
I would love to. I'm going to put to know what's valuable about it. You would want to see what the perils of other types of approaches can be. And so once again, I'm going to share my screen. And
Jeff, I can anticipate someone is going to say, can you share those slides with us after?
No, as long as I get that tutorial from Ishmael on how to make them look nicer.
There you go. And for those who are wondering, Ishmael and Shauna Spence help us with all of these events, and you hear us refer to them often. Go ahead, Jeff.
We could use with some of that in the United Kingdom, I can tell you. So let me offer some exemplars. Now, how do you've decided you want to protect social rights in the Constitution, and maybe you've decided that you want justiciable rather than non-justiciable ones. And I think those are the correct positions. How do you do it? What is the text you use? Here's some examples of what I call absolute social rights obligations. And these obligations are unqualified. Section 9, Constitution of Finland. Those who cannot obtain the means necessary for a life of dignity have the right to receive indispensable subsistence and care. Now, you can do this in Finland, where the whole political system is committed to this principle already. Okay, they can commit to it with absolute, because it's just a working postulate of all the organized parties that the state has to provide people with the basic social minimum. And it's so clear that they can constitutionalize it without having to worry. They don't have to say that the state will take reasonable measures to do this, because they just consider it has to be done. In the UK as well, you could put that everyone has a right to free medical care at the point of service, and not have to worry about it, because it's understood on a cross-party basis that everyone's committed to that already. The Labour Party is proposing to do just this, or at least a constitutional commission of the Labour Party has proposed that. Now, the formula that's in the Constitution of the State of New York says to provide a sound basic education, the legislature shall provide for the maintenance and support of a system of free common schools wherein all the children of this state may be educated. There's a few typos there. Now, in the case of New York, they did not provide sufficient funding for a sound basic education, not least because of this bizarre system of funding education, which is based on property taxes. So some areas are awash with money and other areas are not. And so you had gross inequalities in educational provision. And this led to litigation where courts were ordering the provision of enormous sums, well over $1 billion, to meet the consent order that was established in that case. Now, the problem with this type of approach is that it doesn't, you either have an existing political commitment, in which case you can use absolute language, and there may be features of the Caribbean orders like the NHS or free primary education or emergency medical treatment, which you are happy to state in an absolute and unconditional fashion. But if you state all social rights in that fashion, then it is a message to judges and others to think that rationing to meet those needs is not permissible, provided a claimant can demonstrate that something is indispensable for their subsistence, then they're going to get it under Section 19 in the Constitution of Finland. And in a litigious society, that's what's going to happen. But in most countries, there is a need to ration resources. And the way that's done is usually led by administration, where they set up criteria where they can do it in a fair and transparent way, giving attention to the most vulnerable and so on. You don't do it by seeing who has the money to get to court and lodge their claim that way. So the necessity of rationing is very important. And that's why the model chosen in the South African Constitution, I think, is a good one. They use a qualified social rights obligations. Can you see my cursor on screen? Can I ask?
Yes, you can. We can.
Perfect. Yeah. So here you have the right stated. It's essentially two-pronged. Oh, I didn't know. Oops, what have I done? The right is stated here. Everyone has the right to have access to adequate housing. And then the obligation is stated in the second subsection. The state must take reasonable legislative and other measures within its available resources to achieve the progressive realization of this right. So this is two-pronged. You have the right, then you have the obligation. Now, the fact that it says reasonable legislative and other measures is no accident. When they drafted this provision, they decided the word reasonable was juridically recognizable, and rightly so. And much of the litigation has focused on whether steps that have been taken are reasonable. Now, it's not reasonable in the sense of administrative law reasonableness. There's a good essay by Murray Wesson, a South African scholar now based in Australia, saying that the notion of reasonableness in the constitutional jurisprudence of South Africa is not the same as administrative law reasonableness in English administrative law, for instance. But it's a more muscular constitutional version of this, but nevertheless, it affords flexibility to judges to look at the process of decision making and decide whether some of the measures taken were reasonable, the fact that some measures had not been taken was unreasonable, and so on. This is the provision on housing. Here's the one on healthcare, food, water, and social security. Again, here, the same format. This is everyone has the right to have access to these things. This is the duty to take reasonable legislative and other measures. And here we have an absolute and unconditional obligation, appropriately so. They've decided this is something we can say with confidence will always be guaranteed, and a failure to meet that is not excusable on account of resources. Now, I like this model because it recognizes that rationing is necessary sometimes. If we were to adopt the Bill of Social Rights in the UK, I would advise something that is similar. I have advised something similar to this be adopted. And so that's the kind of model that I think will sidestep some of the problems that have been evident in some parts of the world. And I can say more about what those problems are if time permits.
Thanks a lot, Jeff. I feel as if you have answered in part to Dominic Vassiani's question about whether you can recognize social and economic rights in developing states like ours, and partly in the last answer as well. I wanted to come to the idea of judicial restraint, which is very important for you. I think I mentioned to you that sometimes that's a bad word in this part of the world. But I think it's helpful for us to understand what you mean by it. And if I could double up on the questions, I heard several folks concerned about the enforcement gap. I feel you have answered some of the questions we've had from University of Ghana student Thalia Kershus and Chandra as well. But Andre, Rob also had a question about whether ours may be jurisdictions that don't use judicial restraint in all circumstances because of some of the shortfalls. Whether judicial restraint might generate too little regard for the right. And so Andre's question was, how should Caribbean courts balance the progressive realization principle against the risk that early court decisions may set too low standards? And I was thinking of the Caribbean context, which lacks some of the political conditions you describe in the UK, which are tribunals and other mechanisms, ombuds for dealing with welfare rights, which generally don't exist, and some distrust of the civil service, inefficiency, and so on. So that's many, many questions. Apologies.
No, it's fine. It's absolutely fine. And it's a great question from all of these students. And Andre Rob's question is very astute, I have to say. There's a lot of discussion of this issue. One of the other things that's different about the Caribbean and South Africa is that there was this sort of post-apartheid revolutionary zeal and optimism that was energizing everything then. It's not even there anymore, not to the same extent, because they've had this problem with state capture and Jacob Zuma's brand of politics. That's been a serious issue there. So these are very good observations. So I think that when I talk about judicial restraint, it's really important to know that what I'm trying to do is to say there are good reasons for judges to protect social rights. Politically, it is a good thing to put them into the Constitution. Judges are open to hearing challenges, that they are willing to look closely at the way that health and other social bureaucracies are run, that they are willing to issue remedies where to do so will not distort the allocation of resources. These are very valuable things. But to make the case that judges should be licensed to do this requires dealing with those objections that I had mentioned. Where some systems have been cavalier about those things, there have been significant problems. The most notorious example is in Brazil and also in Colombia as well, where a judge, the judicial attitude was that the Constitution protects a right to health, and that if someone got to court to vindicate that right, it didn't matter how much it cost. If their life depended on getting access to expensive medical treatment in the United States, well, then the judge would order it. And what happened is there's in pioneering work by the legal scholar Octavio Ferraz. He was one of the lawyers that were instructed in these kinds of cases. And what he saw was that elites were essentially using this to get access to very, very expensive medical treatment. So he did a study saying, okay, well, who's bringing these claims? Where do they live in Brazil? And what are they going after? And he showed that the cases were unduly concentrated in the wealthiest states. he had access to the addresses in the public filings. The claims were coming unduly from the wealthier districts in those wealthy states, and the people that were taking them disproportionately were covered by expensive medical insurance. And this is in Brazil. So in some of those states, up to 15% of the state budget for health was being consumed in responding to these court judgments. And that means that the state can't allocate its resources to those who really need it the most. It could be that basic primary medical care for 100 people could be consumed in responding to a judgment that gives experimental treatment to somebody who's pretty wealthy that they don't want to pay for themselves, or that they can't, to be fair. And that's not the best way to run the system. And those kinds of problems were seen by critics of social rights before those problems arose, usually left-wing critics of social rights. So one of the big things that I discovered in writing the book was that the left has traditionally been dead against this kind of thing, because they see rights adjudication as serving the interests of those who have access to courts and liberal politics of restraint and so on. So my providing principles of restraint was a way of saying, look, all these arguments against don't exclude the case for social rights, provided that judges are alive to these principles and alive to the limitations of these kinds of arguments. And that's why I said the case for social rights is sound if judges adopt a theory of judicial restraint that is roughly similar to this. And I think that the principles I identify are those that are pretty instinctively recognized by Commonwealth judges. So that's why I have this bizarre argument that is using the argument from judicial restraint to make the case for constitutionalizing social rights and opening the courthouse doors to these cases. Now, to come around to Andre Rob's question, isn't there a risk that by emphasizing restraint and progressive realization that the first precedents are very, very modest and people are working around those modest precedents? That is a concern. But on the other hand, when those initial precedents are modest, but the attitude of the judges is that we're going to do this one case at a time and proceed incrementally, they become the basis on which you can start to expand the range of the jurisprudence. And to be honest, the risk of the judgment being very wide and a big problem for the system of allocating resources, I think is greater than the risk of a judgment being modest at the outset, but then regarded as obviously right, and the basis, a platform for expanding thereafter. So it's a real risk. But I wanted to add one thing, Andre. There are some who suggest it's definitely not strong enough. The scholar David Landau has an article called The Reality of Social Rights Enforcement, where he argues for larger nationwide injunctions. I don't think that the experience of adjudication in Latin America vindicates that argument, personally.
Thanks so much, Jeff. We are less than half an hour from ending, and there are a couple of questions I wanted to ask, and so I'm taking as part of the participation some of the questions which we've been asked ahead of time by different persons. And I want to come to the remedies question and what's possible in the current system. But I wanted to take Caleb Orozco's question. Caleb is an LGBTQ human rights defender in Belize, is well known, was the primary litigant in the first case which held that criminalization of same-sex sex was unconstitutional and made it clear that the Constitution of Belize guaranteed a right to non-discrimination. And Caleb is essentially asking, will constitutional, social, and economic rights be attentive to inequality, discrimination, and social exclusion? We did hear your own ideas around vulnerability and democratic legitimacy. And so how would you respond to his question about whether the ESC framework applies to LGBT Caribbean people at the national level, and what can be done to strengthen inclusion?
Oh, I think Thank you for that question, and many congratulations on your legal victory. That's a landmark achievement in any jurisdiction. So I'm delighted to hear about that. I think that if you look to the scholars that are doing leading work on social rights, they are often equality law scholars. So Sandra Fredman and Colm O'Canada in Britain are two examples, Lucy Williams in the United States. The connection between inequality, social rights, and race, to pick one of the equality, and gender, is something that is very, very frequently made. I think that the ethos of the idea of social rights is essentially to recognize socioeconomic disadvantage as being something that has a link to unequal status and intersectional discrimination. So in practice, I say that this link is often, at least at the present time, very clear to me. I think it's more clear for those who come to the topic through the human rights movement than those who come up from the old-fashioned labor movement or social democratic politics movements. Labor and social democratic politics are been the main engine for the welfare state provisions actually in the past, and are unfairly neglected, I think, by human rights lawyers. But one thing that human rights lawyers have brought to the table is attentiveness to these kinds of equality considerations. And I think that the kind of disadvantage experienced in the LGBT community is frequently connected to the provision of these kinds of rights: education, employment, housing, social security benefits, succession to tenancy if you're in with a long-term partner or a spouse, a common law spouse effectively, and they die, will you succeed to the tenancy or not? I mean, that is a huge constitutional case in the UK. And it's precisely in those areas that recognizing things like housing as a fundamental human right emphasizes, in connection with the inequality dimension that LGBTQ members of the community are suffering. It emphasizes the wrongness of that kind of discrimination at a really fundamental level. It's wrong no matter what the interest is, but it's especially egregious when it relates to those kinds of interests. So I think that there is a very congenial, mutually reinforcing relationship between seeing social rights as human rights and recognizing discrimination of that sort.
Thanks so much, Jeff. So I wanted to come back to this question of remedies, as well as what's possible with what we have.
Yes.
So we've talked about what reform could look like. South Africa has been the model we've been looking at. But we have existing provisions. We have judicial officers in Ghana, in Bahamas, in Trinidad and Tobago, from many other jurisdictions who are here, who are asking, if this comes before me, what should I do, or what's possible as practices of interpretation?
I see. Okay. So I think that my understanding is that full constitutional recognition thus far, where it's straightforwardly justiciable, is fairly limited. The right to work is the main principal example. If I understood Justice James's writing accurately, that is the case, but that a larger suite of social rights is being contemplated at the moment. So is that correct? Is that correct, Tracy?
That's correct. And Westmin is also here.
Yes.
But yes, so, I mean, it's been the one which has been litigated the most, the right to work.
Sure.
There are more limited rights to education, to a healthy environment.
So I just wanted to say a few words about how ordinary public law might be construed, how the protection of social rights might occur in ordinary public administrative and constitutional law. So the first thing to note is that in this field, there's a ubiquity of statutes. It is densely covered by statutes. It's not like a typical, in freedom of expression or protest, that a police officer shuts down a protest. We're talking about, typically, at least in my experience, a dense statutory framework. Sometimes there's public guidance added to that, or there are statutory instruments that are overlaid. So you're dealing with a lot of textual law that requires interpretation and administrative discretion that is within there. So you have ambiguous provisions often that require interpretation. And that makes space for different sources that can be relevant. So the most obvious source, I think, are the constitutional preambles that Justice Westmin James has indicated in his chapter. So there is reference to social rights, or at least the importance of the social state in several of the preambles. And he indicates there that the preambles can play a constructive and creative role. The creative role is that the preamble, and I'm quoting here, is relevant to the interpretation of statutes where there's ambiguity or difficulty. This is a very common mode of interpretation in public law in the UK as well. So here, where there is ambiguity or difficulty, recourse, it sounds, can be had to the constitutional preambles. And since there is a lot of statutory and delegated legislation requiring interpretation, there is some role, I think, for reference to these social principles. Another source could be having regard to the unincorporated social rights treaties. So, as you point out in your preparatory materials, the International Covenant on Economic, Social, and Cultural Rights has been widely ratified in the region, I think by all but perhaps one of the Caribbean states. And I'm not sure what the doctrinal position is in Caribbean law, to the extent that there's a communal Caribbean law. But it is in Canada and the United Kingdom and a few other countries, it's permissible to have recourse to unincorporated treaties to help with legal interpretation where the statutory provision under consideration is ambiguous. That is a recognized standard of interpretation. Now, I've never seen that standard be used to give a very muscular application of social rights provisions. It tends to have to be that the international law speaks very clearly to the issue. That will, to be honest, that'll be rare with the Covenant, because the Committee on Economic, Social, and Cultural Rights often has extremely general statements. Like the committee is concerned that there's a lot of poor people in this part of the world. That's the kind of way that they like to phrase their concluding observations. But sometimes there's an issue that arises, and so recourse can be had there. Another point, this might be more relevant to judges that are listening, and possibly to litigants as well, or attorneys, is that in conventional administrative law, we have different grounds for judicial review. There's procedural impropriety. There's, what Lord Diplock referred to as legality in the GCHQ case, i.e., have they taken into account relevant considerations? Have they interpreted the statute properly? And then there's substantive review. Was it reasonable? And the traditional standard applied was very deferential, a Wednesbury review. However, in the mid-1990s, there was a movement, or there wasn't a movement, but there was an attempt, which was largely successful, to encourage that judges to show a bit more searching a degree of scrutiny when fundamental rights had been interfered with, the so-called anxious scrutiny. And the case for that was the case of Ex parte Smith. And I think that although this, and I'll give the citation in the PowerPoint deck afterwards, although that was concerned primarily with civil and political rights, it's not too far a stretch to say that when someone's social welfare rights are interfered with, that the court can exercise a more searching form of review in that case than they might have traditionally done under Wednesbury. So I think substantive review, it's statutory interpretation, and these sources, whether it's preambles or international law, can provide something of a footing for social rights jurisprudence. The last point is about interpreting the civil and political rights provisions to have social dimensions. Now, it's mentioned in the materials that the right to life has been interpreted this way. And certainly in India, it has. I think there is some scope for reading the rights in such a fashion. However, there's a risk that by reading an instrument in a way that is considered to be quite different than what was expected when it was adopted, to go into a new territory without a sufficient constitutional or democratic license, I feel that the risk there of political backlash is a real one, and it could really backfire. So I'm not entirely in favor of that kind of approach that's been followed in India, if I'm honest. I would favor just the kind of thing that you're doing now, which is to amend the constitutions and recognize them. And then this mandate issue is off the table. So in the UK, we have fierce backlash against human rights. And the best argument about it is that it's right there in the Human Rights Act. Parliament voted for this. And I think you'll be in a similar situation if there's pushback against the idea of social rights, that this was part of a democratic process to reform the Constitution and recognize them.
Thanks so much, Jeff.
My pleasure.
Noel Nichols, who is joining actually in the Zoom room, who is an LLB student from the Bahamas, notes that the questions of constitutional reform are harder in the Bahamas than they are in Barbados and in Trinidad and Tobago, where, for example, referenda are not a central dimension. The Bahamas has had 2 failed referenda in the last 20 years. And so for her, some of the other arguments about what judges can do, I think, bearing in mind some of the concerns you raised, is important, and particularly the incorporation of indirect incorporation of international human rights norms through principles of interpretation where there's ambiguity. I'd simply say that there are tensions in these positions between the CCJ, the Privy Council, and more recently, the Privy Council, and I think of the case of Tafari Morrison, has adopted an exceptionally conservative approach to looking at treaty obligations of Jamaica. Here, the Convention on the Rights of the Child, in a case interpreting a constitutional provision relating to children's rights. And interestingly, the political dimensions of this discussion in the Caribbean are those states that are closely committed to the JCPC jurisdiction, of which I think there's no stronger than the Bahamas, given that it didn't ratify the CCJ agreement, and others who are struggling to get there, and then a number that are jurisdictions that head to the CCJ. So multiple different options and opportunities, and also challenges in the Caribbean. We're wrapping up, Jeff. We've taken several questions which we received before, and we've been looking at the chat to hear some of the comments from those who are joining us. But I wondered if you had any last thoughts, and it may include something about the remedies as well, as we close off at 1:30.
Okay. I think I did want to say something about the kinds, if you did put the social rights provisions into the Constitution and using the kind of qualified rights formula that I'd mentioned, there is a question about what kind of remedies would follow. And I think that what is appropriate depends on the legal and political culture in the state, in the jurisdiction you're in. Ideally, remedies which provide some options for the state to adapt to shifting information are useful, but whether or not that's just too much of a license in a particular jurisdiction is an open question. Now, so I tend to think that quashing and declaratory relief And where there is a statutory provision that's unconstitutional, an invalidity declaration accompanied by a suspension of that declaration, which I understand the Bisram and DPP Guyana case alludes to, although that wasn't in quite the same form as the suspension of invalidity declarations that you find in Canadian constitutional law or German or French constitutional law these days.
And I just say that Justice Corcoran has done this in Trinidad and Tobago when he was in the High Court, and Justice Ventos in the Sir Kitts and Nevis case as well. I think in the format you're describing, yes.
I think that's, I say humbly, I think that is the right kind of constitutional remedy for most, not all, but most complex social rights cases. The one thing is supervisory jurisdiction. I think it's seen sometimes as a panacea. We don't have to resolve what should be done. We'll just tell the parties to negotiate, and we'll appoint a master to supervise that. This has been done to a large extent in the United States, but it's not entirely clear that is what is best, because it ends up being that private lawyers negotiate with the state to determine the social policy of sometimes really important areas of policy. Sometimes it is important, like prison reform litigation in the US, but with education, there are a lot of criticisms with the way in which litigants have started determining huge amounts of social policy behind closed doors with public officers. So I think it's only as a last resort that remedy should be approached personally, and rather than as a first port of call.
Thanks so much, Jeff. Jeff, you've raised, especially in the end, several important ideas, which I know others will want to continue to talk about. We've been listening online to those who are keenly listening to your ideas as well. I'm sure some will pick up your book and read more closely as well. But your ideas are very much of moment now. And not just the book, but in talking to you, there's a kind of clarity that really helps those of us who are thinking about this in the Caribbean, both as a question of design and adjudication. So for that, we're extremely grateful for your time this afternoon and evening in what is Miami for you, rather than the United Kingdom, thankfully. But I'm going to hand over to Justice Jamadar to help us to close off the evening.
A huge honor. Thank you very much.
Thanks so much.
Thank you very much, Tracy. And Jeff, taking the time and sharing so clearly, and I think in ways that help us think about these issues from all perspectives. And I think that's very important for us here, because the tendency can be to want to rush into a position. And I think one of the values in what you've done is, apart from giving us a real sense of the landscape, broad and deep, is in doing that to help us recognize that the issues are complex, the solutions are not always straightforward, hence your recommendation of judicial restraint, which I think in this area is well stated. And of course, you've justified why that should be so. It's time for us to say that this must come to a close. Of course, these kinds of conversations, there are people in the audience, no doubt, who would have liked to ask something or said something, but it's not always possible. Tracy, you've done a wonderful job to facilitate integrating questions into what we've done. And so I just want to say to Jeff, to Tracy, to MonaLaw, to the CAJO, to the CCJ, the people who are behind the scenes, who've been behind the scenes from the beginning and remain behind the scenes, and of course, to all of you who have joined us and have stayed the course, thank you all very, very much. It's only left for me to end by saying that this is, in fact, the first public-facing event to celebrate the 20th anniversary of the Caribbean Court of Justice. And it is a great pleasure for me and for the CAJO to have partnered with MonaLaw and Jeff to have you feature in this celebration of our 20th anniversary, and to do it around this issue, because this is a forward-facing issue for the Caribbean. And I dare say, even if it does not find form within constitutions, and Trinidad and Barbados have in 2024 recommended that it does, even if to a limited degree, I still think that issues are going to come before courts. And at the end of your conversation with us this evening, you have shared 5 or 6 strategies that judicial officers and attorneys can deploy to try and address social and economic rights as they arise in litigation and in our communities. So thanks to everyone. Have a good evening, and we wish you all good things. Thank you very much.
Thanks, everyone. Thanks for joining.